So the first main choice when you are thinking about which type of representations you should use is which of the three main categories of representations is most suitable for your product, or which two or maybe or even all three should be used for your product. So here we have three examples of the main types of representation. These are line drawings, grayscale, and full color. So the first example there, line drawings. So you can see on the right there a piece of audio equipment that is represented with black lines that demonstrate the shape of the product. So this provides a protection for only the shape of the design and won't be influenced at all by any color. The second option you have there is grayscale representations. So these introduce relative shading. So we can see there that there is a dark faceplate and a lighter housing. And so any colors that conform to this pattern will be protected by a registered design with grayscale representations. And finally, we have full color representations. So here you can see the audio equipment has a red housing, and this red has a big impact on the appearance of the product, and so has a big impact on the ultimate protection of the design. So this, for example, would be unlikely to protect a similar product in a blue color, for example. The trade-off here is that if a competitor uses your red housing color, but changes the position of the knobs and buttons, then the overall impression produced by the red is going to give you a good chance of still capturing that product despite those variants, as long as the overall appearance of the products is similar enough. Now, getting your choice of representations is very important. So here we can see a couple of pictures. So the picture on the left is a registered design representation from a case filed by a company known as Trunky. So this was the subject of a case that went all the way to the Supreme Court a few years ago, and it related to a potential infringement by the product that you can see there on the right. And the decision by the Supreme Court ultimately was that the registered design on the left did not cover the product on the right, and this was because of the type of representation they'd used. These grayscale CAD representations were found to restrict the registered design to a product having a single uniform color body for the suitcase, being a lighter color than the dark wheels. The decision noted that the suitcase on the right there had a decorative print applied, and so didn't conform to the single color that appeared to be required by the CAD file that was filed on the left. So ultimately, as I say, it was found that this product did not infringe this registered design. Now, had the application been filed with line drawings instead, we expect that the design would probably have been found to be infringed, which indicates just how important it is to get your representations right. So here are some more representations, this time for Hasbro Nerf guns. You can see here the different views that we typically file within one application to show the different sides of the product and help build up a picture in 3 dimensions of the product. And you can also see here another of the tools that we have for adjusting the scope of protection of a design. So the magazine that sticks out to the left of the Nerf gun is shown in dashed lines, and this means that this magazine is not claimed in the design. And this was because we wanted to protect this Nerf gun regardless of whether there was a magazine inserted into the product and regardless of the type of magazine that was inserted into it, so the shape or size of the magazine. Here are some more representations from a design application that was filed. So this was the design for a fuse tester that had the appearance of a ladybird. So these were 2 views included in the same application. The view on the left showed the fuse tester with some doors on the back closed, giving it the appearance of a ladybird. And then we wanted to show that the doors were openable. So we included the image on the right, which showed these doors opening, revealing a compartment on the inside. And so this meant that the registered design included as part of the appearance of the product the fact that it had these openable doors for a compartment. So what type of protection does a registered design afford? Well, a registered design is a negative right, and it allows you to stop anyone from making, using, selling, importing, or exporting a product embodying the design. Now, the design doesn't need to be exact, as long as the product that potentially infringes the design produces the same overall impression, that's the legal test, it will be covered by the design. So what does the overall impression of a design mean? Well, this is a very complex subject and could be the series of a whole other talk. But here are a few points that influence the overall impression of a registered design. So as the term implies, the overall impression requires you to look at the whole of the design and compare it with the whole of the product in question. So a common tactic you will see when people are defending against design enforcement is that they will try to produce a long list of differences between the potentially infringing product and the registered design. However, deciding what the overall impression of a design is requires weighing up the differences and the similarities and their significance. And you need to take into account how visually striking these differences and similarities are. If there are relatively few similarities, but they are visually very striking, then it may be that they have the same overall impression, even though there may be a long list of differences between the product and the registered design. So overall impression also takes into account design freedom. So do certain aspects of a product have to look the way they do? So for example, if you think about a glove needs to have 4 fingers and a thumb. And so the shape of a glove is limited and there's not much design freedom there in the overall shape. Finally, registered design protection, the overall impression is influenced more by features that differ from the norm. So for example, if you take the example of a mug with a very intricately designed handle, then the overall impression will be dominated by that slightly unusual and intricately designed handle, even though the bulk of the product is actually in the body of the mug. Okay, so now all those asterisks come back to bite. So we're on to the final part of the talk, and we're looking at the effect of Brexit on designs in the UK and Europe. So as part of the EU, both registered and unregistered community design rights have covered the UK, and unregistered community designs were also generated by disclosure in the UK. Now, during the transition period, it's as if we are still in the EU and this all still applies. However, from the 1st of January 2021, this will end. So this is going to affect both registered and unregistered designs. So for the future of registered designs, the future is quite clear. Future registered community designs will not cover the UK. So in order to cover the UK and EU, you will need to file separate applications at the UK IPO and the EU IPO. Existing registered community designs will be cloned after the end of the transition period to produce corresponding UK registered designs. Now, this will automatically be done, and so anyone with an existing registered community design will need to ensure that they just simply identify these new cloned rights and start making the payments of any renewal fees that fall due on those rights. If you file a registered community design close to the end of the transition period and the design hasn't registered by the end of the transition period, then the pending RCD will not be cloned. However, there is a mechanism that will allow you to file within 9 months a new UK registered design application using your pending registered community design as basis for this new UK application. So the future for unregistered designs is a bit more complicated. So as I mentioned before, unregistered community designs currently provide that 3-year protection for 2D and 3D articles, both in the UK and Europe. However, at the end of the transition period, this type of protection will cease. So what the UK is going to do is it's going to introduce a 3rd type of unregistered right to replace the type of protection that's being lost there. So this new type of unregistered right will not be generated by disclosure in the EU. And likewise, unregistered European community rights will not be generated by disclosure in the UK. This means that you will probably find it difficult to rely on unregistered rights for both protection in Europe and the UK. You may be able to obtain protection in one territory, but it's unlikely you'll be able to obtain unregistered protection in both. Now, one way to fix this is to register your design, at least in whichever territory does not get the unregistered design rights after the end of the transition period. Or for stronger protection, we typically advise registering the design in both territories. If you want any more information, you can head over to our website there. And if you have any questions, please feel free to email me. My email address is there, or contact me on LinkedIn. You can see my handle there on LinkedIn.